Welcome to my presentation about the False Claims Act and Infosys's visa fraud with whistleblower Jack Palmer. Infosys was investigated for a visa fraud scandal that violated conditions for the B-1 visa and potentially stole millions from the United States economy. At the end of the investigation, Infosys settled the case for $34 million. The fraud was brought to light by a whistleblower named Jack Palmer under the False Claims Act. Here is the timeline of events. In March of 2010, an executive meeting is called where Palmer suspects fraud. In October of 2010, Palmer files an internal report at Infosys about the wrongful use of B-1 visas. In February of 2011, Palmer files a lawsuit against Infosys. This spurs a federal investigation. In June of 2011, the founder of Infosys expresses concern about the use of B-1 visas, and he resigns. In August 2012, Palmer's lawsuit is dismissed, but then in October of 2013, more than a year later, Infosys settles the case with the government for $34 million. Here are the stipulations for an H-1B visa. First, there must be an employer-employee relationship with the petitioning U.S. employer. Second, the job must qualify as a specialty occupation within the United States. Third, the specialty occupation must be related to the visa holder's field of study. Fourth, the visa holder must be paid at least the prevailing wage for that occupation within the United States. Fifth, the H-1 visa number must be available, and there's only a limited number of visas available. Notice that these requirements are very specific and restricting. The H-1B is used to protect the skilled labor of American citizens. Additionally, it is important to say that the H-1B is the only visa that is considered a stepping stone toward a green card or citizenship in the United States of America. Therefore, H-1B visas are incredibly valuable. Here are the stipulations for a B-1 visa. First, the visa holder must be in the United States for only a short, defined period of time. Second, the visa holder must engage in business with a United States entity. Third, the visa holder may gain no salary from a United States entity. Note that not only are these requirements much more vague and short than the H-1B requirements, but looking at the wrong light, they could be construed to have a similar meaning to the H-1B visa, but with less restriction. The third stipulation, however, prohibits salary from a United States company, which, again, is used as a protection of the American economy and American jobs. Here are the accusations against Infosys. First, that they held inaccurate I-9 records for foreign nationals. Second, that they falsified the invitation letters for these nationals to the U.S. consular office. And third, this is the big one, Infosys provided B-1 visa holders with instructions on how to deceive U.S. officials into thinking that they weren't here as contractors. And here is Infosys' response. They say that the B-1 visas were appropriate for the work being done by the contractors in the United States. They also said that the invitation letters to the U.S. consular office were accurate, and also that the instructions about interactions with the U.S. officials are common and used by many companies. These are the violations that I think Infosys made. Infosys had malicious intent and intentions to deceive the United States. They were looking to profit from American companies who want to cut costs by using cheap foreign contractors. But this stripped Americans of skilled, high-paying labor jobs. So what, though? What are the economic effects of what Infosys has been doing? Well, look at this timeline. First, Infosys hires skilled foreign contractors at a fraction of the U.S. labor cost. Then Infosys sends them to the U.S. on B-1 visas. At this point, Infosys has not violated the law. However, companies, seeing Infosys' much lower contract rates, hire these foreign contractors and pay them, which is against the B-1 visa contract. The worst part of it, though, is that by hiring these foreign contractors, they're hiring them instead of American contractors, instead of skilled American employees, and potentially instead of their current employees who could be working on useful projects for the company. Thus, the American economy loses millions to Infosys in their cheap foreign labor illegally brought into the country. This is very bad. So I mentioned Jack Palmer earlier. What's his role in all this? Well, he's the whistleblower, the one who told on Infosys and filed the first lawsuit against them. He was asked to help draft paperwork for the fraud while he worked at Infosys, but he refused. Infosys, instead of quietly sulking away, responded very poorly to his refusal to do work for them. After that, still working at Infosys, he gathers information about the fraud from within, and then, later, files a lawsuit against Infosys under the False Claims Act. So what's this False Claims Act? Well, it was passed in March of 1863 in response to rampant fraud during the Civil War. It was referred to as the Lincoln Law because it was passed under Abraham Lincoln's administration. It's used to combat parties who are looking to defraud governmental programs by charging them more or violating laws, things like that. This act allows citizens who are not related to the government, called relators, but really they're just whistleblowers, to file a lawsuit on the government's behalf. It's important to note here that just because a whistleblower files a lawsuit doesn't mean that the government is required to follow up with it and under the False Claims Act. The relators gain 15 to 25% of the settlement or damages from the case. This is huge because a lot of these cases are multi-million or potentially billion-dollar cases. This is how Palmer received a large portion of the money that Infosys settled on when they settled the $34 million deal. I've come up with a few alternatives or more fitting punishments that could have been levied on Infosys. First, the case should have been settled for much more. $34 million is not a huge amount for them, and much of it went to the attorney's office anyways, not back into the economy. The majority of this larger fine or settlement should have been carefully injected back into the economy in the sectors where Infosys had the most disastrous effect. We could also have restricted their visa applications permanently or for a period of time, not allowing them to or severely restricting their ability to conduct business in the United States. Finally, it would have been prudent to terminate the employees who were instrumental in perpetuating the visa fraud. So here's my final verdict. There is gray area in the law where visas are concerned. This enabled Infosys to rationalize their actions in using the wrong visas. However, these actions should have been examined and fixed within the company before actually being implemented on a large scale, or at all. Infosys' innocence or guilt was never proven, but from the evidence I've gathered, I consider them guilty of intentionally sidestepping the rules for avaricious purposes. Finally, I believe that the False Claims Act is a useful and necessary piece of legislation that provides incentives for ethical actions from both companies and whistleblowers. Thank you for watching my presentation.